come in and join in us today. This is the first time we're doing this, but as Dr. Nelson said, we're hoping to continue this, doing this every once academic semester. And I have some topics that I think would be of interest to you. But if you've got some topic that's a burning topic in your mind and you want us to cover that during the seminar, then we'd be happy to take the suggestions. Of course, the plan that we have is in general to organize it such that we get one external speaker who's going to talk about a specific topic and discuss the legal aspect of it. So since this is the first one, I thought I'd sort of go over some of the basic concepts of intellectual property law and talk about how, as an academic, it might affect us and what we can do to promote this environment of technology transfer a little bit more. So what exactly is intellectual property? And really, there's 4 different types of core IP assets that an organization such as Oakland University or any other organization could own, and they're patents, trademarks, copyrights, and trade secrets. Essentially, patents would confer limited monopoly on an invention, so you're the only one who can practice that invention for a limited period of time. And going back into the historical underpinnings, there was a big debate between Thomas Jefferson and I guess the president at the time. And essentially, Thomas Jefferson was against monopolies, and we as a country are against monopolies. But in this particular instance, because this affects the entire sort of state of the art that a country has. I mean, a country's intellectual assets are what really sets it apart. So that's what Congress chose to grant the monopoly to the inventor for a period of 20 years, starting from the date of file. And of course, trademarks identify source. That's not so relevant to us particularly, except that we need to be aware not to misrepresent Oakland University's trademark in any way. Of course, copyrights are going to be an area that I think would be of interest to departments not that are above and beyond engineering, computer science, and medical, which are primarily going to be focused on patents. And copyrights could be of interest to some other, for example, media and art departments here at the university. Because trade secrets are something that we should be aware of, and how it affects our daily work is something that we should be cognizant of. And essentially, trade secrets are those elements that we want to keep protected. And essentially, what it takes to protect something as a trade secret, I want to mention a little bit about. There are other IP assets as well, such as databases and general business methods that we won't really touch upon that much, but just to be aware that those are also things that can be protected. Here is a patent over here. This is Edison's patent for the electric bulb. And of course, that's an example of a patent. And at the time when Edison and Bosch and some of these original inventors were getting patents, it used to take roughly about 3 months to get a patent. And one of the examiners was of course Thomas Jefferson. And in the original Patent Act when it came out, Thomas Jefferson was the Secretary of State at the time, also along with the Secretary of War, with 3 examiners. And I think the president was the 3rd examiner, if I'm not. Maybe David can shed some light on the history of it, but that's what I recall it was Alexander Hamilton or someone who was the 3rd examiner. At that time, it used to take 3 months to get a patent. Now it takes close to about 2 to 4 years, depending upon how crowded the art is. And of course, copyrights, I just shown an example. A lot of our faculty may be building models that are stick models that just do a 3-dimensional visualization of some scientific concept. Of course, that is protected with a copyright. And of course, there's a trademark. We all are familiar with the famous trademark of Ralph Lauren. And trade secret, I guess it's an example of a trade dress as well as trade secret. What is inside the bottle is a trade secret because nobody knows the formula of it. even if I didn't put any label in here, you'd be able to tell that that's Coca-Cola. So that's sort of telling you that it's a Coca-Cola bottle, even though the name's not really spelled out. So that's an example of a trade dress, which is also intellectual property. So anyone using a similar bottle or a similar looking bottle would be on Coca-Cola's intellectual property. So what is a patent? It's essentially, it's an exclusionary right. It gives the patent owner a right to exclude others. They may not practice the invention at all, but they have a right to exclude others. Patentees can enjoin others from making, using, and selling, or importing infringing invention, even if someone was to think of this on their own independently. Someone in this country comes up with the same invention independent. Even so, if you got a patent, you can sort of enjoin them from making, using, manufacturing, or importing that invention into this country. So given that, just because you've got something you haven't patented, if you want to protect that invention, you have to patent as early as it's feasible. Feasible is something that I'm going to talk about in the next slide. But essentially, there is some advantage to patenting because you can't say that I came up with this first, especially after AIA, the America Invents Act, which really gives rights to the first inventor to file. So you have to file for a patent. Just as a little trivia, first patent was issued in 1790 for making potash, fertilizer. First patent examiner was Jefferson, and later on, the patent office was actually set up at its former building. That's the first patent office in the city. Okay, so what are the three things that we talked about feasibility? What makes it feasible to get a patent? Well, you've got to have the first threshold question. Is this something that you can patent? For example, you cannot patent equations, you can't patent laws of nature, you can't patent natural phenomena. So that's the first gate. Is it statutorily patentable subject matter? And the second question is this novel? Has anybody else patented this idea or this invention before? And that goes to publication. Has anybody published about this invention before? Has anybody got a patent on it? Not only in the U.S., but anywhere in the world. Is there a patent existing on this invention? And of course, and the third gate that you have to cross in order to get a patent is that of obviousness. Is it, given the existing state of the art, is it obvious that someone could come up with this invention without much, anyone who's skilled in the art, or would it be obvious to them, this invention be obvious to them? So those are the three gates that you have to go through, and that's the feasibility. That's the feasibility that I was talking about in the previous slide. Of course, that you have to make sure that it's feasible, and of course, one other statutory requirement that I've mentioned there is that it should be enabled. What that means is that someone looking at your patent specification should be able to build your invention without anything else. Okay, someone who's skilled in the art should be able to take a look at your patent specification and build that invention. So that's Section 112 of the Patent Act, which is that it should be enabled. So, like I said, the patent prosecution process typically takes about 3 to 4 years. But for some of the crowded art areas, such as pharmaceuticals, computers, and software, it could take a little longer. But then we get into some adjustment of the patent term if it takes longer than 3 years. Okay, let's talk a little bit about copyright protection. This is statutorily provided under Title 17 of the United States Code. Section 1 or 2 talks about copyright. It really, and I had mentioned this before, but both copyrights and patents are the rights for inventors to own their inventions, and original work of expression comes from the Constitution. Title 3 of the Constitution, Section 8, provides these rights. So these are constitutionally granted rights, and essentially the Congress is really implementing them through statutes. And 17 U.S.C. 102 talks about original works of art authorship. It has to be fixed in a tangible medium of expression. In other words, if it's not, if I'm giving this lecture, nobody's recording it, and it's not really fixed in any kind of a tangible medium of expression, so that there is no copyright protection for that work. But once it gets fixed, for example, like in video or audio, then the copyright will start to attach to that expression as it's fixed in the tangible expression. So of course, facts, data, utilitarian elements alone do not satisfy the requirements of copyright law. So you can't really copyright facts or data. It is only in expressions of the copyright attached. So the statute gives about 8 separate categories in which copyrights can be obtained by applying to the United States Copyright Office. These include works, literary works, musical works, graphics, sculpture works, motion pictures, sound recordings, and architectural works. And computer programs, databases, and websites are treated as literary works. So you can get copyrights on computer programs under the subheading of literary works. So there is a very famous case of Baker versus Selden, which talks about the idea expression dichotomy. So you have an idea, you cannot really protect the idea at all by itself. You can have an expression of the idea that you can protect under a copyright. And you can have another expression of the same idea, and if this second expression number 3 is similar to the expression number 2, then a copyright infringement has occurred. So in order for infringing on somebody's copyright, your expression of that same idea has to be substantially similar to the other expression in order to actually infringe on it. So we don't want to let people own ideas, but we want to let the creative expression of those ideas be ownership of individuals or entities. So some examples of what is copyrightable. For example, this is the the nanostructure called buckyball. If someone creates a three-dimensional representation of it, even builds a stick model, that would be protected as a copyright. In other words, nobody can take that and copy that in that same form, substantially similar form. Of course, you have a piece of software. You have a piece of software is considered a literary work, so it's protectable. So if you cut a disk with that executable code of the software, like the one that runs on a computer, the exe file, as most of us are used to seeing, that exe file, the bit pattern, the bit string in that exe file is protectable as copyright. So nobody can really make a copy of that, identical copy of the exe file, and you can protect it. So the idea for performing a computer search of databases using a phonetic or voice input is not copyrightable. You can probably get a patent on it if you actually cross those 3 gates, 101, 102, 103. But you can take a computer program that implementing that search might be protectable. Similarly, using an average change in the value of portfolio securities to compute a score is not protectable. Just that idea, okay, I'm going to take this average value of how much the securities gain, the capital gain, and that's going to be the score for my portfolio. That idea is not protectable, but a computer program that does that automatically, and of course they would be talking about some of those things as well. Since we're focusing today on business method patents, and for the computer program that takes that concept and implements it is protectable as copyright. But remember that copyright protection only extends to the expression. So someone can take that algorithm, if you publish it, and come up with a different program, and that's not going to infringe on your copyright even if it protects your program, because their expression, how they set up their variables, how to set up their loops and all of that, is not going to be substantially similar to how you set it up. Okay? So they're not going to infringe on your copyright even if you have a copyright protection. So the example that I give is that if you've got a labor-intensive, a sweat or a brow kind of a thing, if you've got a labor-intensive expression, you took a library of functions and coded it up and got a copyright on it, and these are all very utilitarian kind of functions. Nobody can take, copy, and paste that set of functions into their program without infringing on the copyright. So that's the idea. But they could take those set of functions, their the mathematical expressions, and code them up themselves, and they would not be infringing on a copyright. Of course, if you had a patent on it, that's a different matter. The substantial similarity is the threshold for infringing on copyright. Okay, so let's briefly talk about the law of trade secrets. A trade secret is defined as valuable business information. It could be a formula, it could be a way of doing things, it could be anything, any kind of information that really affords a competitive advantage or benefit to the owner of the trade secret. So whoever owns the trade secret has some advantage because of that. If that's, in order to protect something, as I said, formulas, patterns, programs, devices, methods, techniques, processes, that actually give an economic benefit to the trade secret owner are protectable as trade secrets. And essentially, two rules that we have to check to see if something is protectable as trade secrets. Number one, it should not be generally known or readily ascertainable. In other words, nobody should be able to look at this and say, okay, I can reverse engineer it very easily. It should not be easily it's one of those tongue twisters. It should not be able to ascertain it easily, but it should not be generally known. And the second thing is that it should be subject to reasonable secrecy. In other words, you can't have pulled it out open and say, okay, I'm going to publish this, and then it's still going to be a trade secret. No. And so those are the two questions when it comes to trade secrets that one should ask. In order to protect something as a trade secret, its owner must safeguard it with reasonable measures. So there should be reasonable measures in place to protect that trade secret. For example, the legendary formula of Coca-Cola is locked in a vault and accessible only to a handful of executives. I think it's only 2 people who have access to that formula. So that is definitely reasonable. So, unless it's a real quick.
I was wondering if customer lists are trade secrets.
They can be. Okay. They can be trade secrets. Customer lists.
Or data, generally.
Yeah, generally would be. It depends on if they're guarding it. But, so reasonable measures would come into play. Are they subject to reasonable secrecy? All right, so what are some of the remedies so first of all, trade secret law is not really a federal law. So like copyright patents, trade secrets are not federally regulated. There is a National Conference of Commissioners on Uniform Trade Secrets. They drafted this Uniform Trade Secrets Act, USTA, to promote uniformity across different states in how trade secret law is implemented. And that has been adopted by 45 states. So essentially what your lawsuit will be based on misappropriation of trade secrets when a person uses improper means to possess, disclose, or use a trade secret owned by another without their express or implied consent. So in other words, you steal it, you hack into the computer, you get an employee to give it to you, or you just kind of mount a camera in there and see how they're doing things or whatever. All those will be considered inappropriate means, and and that's misappropriation. Courts generally grant punitive damages, so they really are not only giving you compensatory damages, but they're also saying that's really bad. You want to discredit this kind of practice for misappropriation. So punitive damages are available in violations of trade secrets. Someone misappropriates someone's trade secret, then punitive damages will become available. As an example, Toshiba was asked to pay $380 million in compensatory and $84 million in punitive damages for Lexar Media's trade secrets under the camera. So as an example, that California jury awarded pretty high damage. So let's just quickly talk about the interplay of trade secrets, copyrights, and patents. Okay, because we talked about these 3 things. So as a faculty, what my suggestion to you would be to protect your intellectual capital as a trade secret till a point in time where you're ready to actually go and patent it. Okay. Now you would say that what about publication? And yes, of course, in the United States we have a 1-year grace period. You can publish, and as long as you file a patent within 1 year of that publication, that you're covered. But that's not really the case if you want to go and get a patent overseas. You're not going to get that 1 year grace period. So perhaps it's a good idea to sort of keep it a secret, and once the patent application is filed, not until it's issued, it could take up to 3 years to get issued. So once it's filed, you can start publishing. Okay? It's okay to publish at that point. Okay? But so till that point, till you file that patent application, you've got to protect it as a trade secret, if it's got some commercial value. And we're going to talk. I've got some slides about that going forward. So publication should be avoided, unless if you know that this only has application only in the United States, and I'm 100% sure that no third world country or developing country wants to get hold of this invention, then it's okay. So, for example, you can get a copyright of machine code. So if you want to make machine code available to people, just have them, have it copyrighted. You're covered there. User manuals and other, types of things. But protect the source code as trade secret. Okay? Protect your source code, because that's, so what it means is that perhaps you have to have non-disclosure agreements signed by people who work for you, okay? Or have them sign a non-compete clause that you can't take that, they can't take that away when they go and join someone else's lab or some company that may be interested in your idea. So essentially copyright your executable, and then nobody can make an exact copy of of that executable file, but protect your source code as a trade secret. Because you might come up with a new version of that, and you can come up with an enhancement. So keep your source code to yourself if you can. Generally good at that. Okay, so let's talk a little bit about IP attitudes, how they are changing. That's really the substantive part of my presentation. I want to get everybody on the same page before David comes up and gives this talk. And essentially, the intellectual property 10 years ago, the phrase was not even in the vocabulary of most CEOs. Still, many CEOs still regard patents, trademarks, copyright. Talk to my attorney about that. Okay. But if you look at Fortune 500 companies, that they were 60% of the market share was represented by tangible assets, buildings, equipment, inventory, whatever the tangible assets were. That was back in '75, and now that's just dropped to 20 to 25% of their assets are intangible. So intellectual assets are accounting for roughly about 80% of Fortune 500's market capitalization is related to IP. So they treat them as assets. And 80% of their assets are intellectual property. Total intellectual capital held by U.S. public companies rose from 6.3 trillion in 2005 to an estimated 8.1 trillion, to somewhere in that neighborhood in 2011. And this really represents about 60% of U.S. GDP in 2010. So that's how much IP is owned by companies today as the United States. Now let's take a look at the top 10 industries with the largest stock of intellectual capital. First, the topmost is energy. Energy companies have a lot of IP. The next on the list is software and software services. Next is insurance and other finance companies, capital goods, pharmaceuticals, biotech and life sciences, technology, hardware and equipment, food, beverage, tobacco, etc. So we're seeing that energy is at the top of the list in terms of how much IP is owned by companies. Energy companies own the highest amount of IP as a percentage, the basis of the total value of IP. That's all. It could be because the IP that these companies own just has a high value. Because energy, everybody needs energy, right? So on the same point, you've got to remember this, that if you've got an intellectual property that is based on, that's sort of enhancing energy efficiency or coming up with alternate ways of producing energy, then probably that's something that should be patented with the PCT for international patent, because that is something that's not only going to confer advantage to the United States, but that is something that developing countries need excessively. So that's not something that you want to patent only in the U.S. You want to patent that in some of the BRIC countries, perhaps, to make sure that those ideas are protected. So, what about IP at universities? Okay, Harvard in 1975 had a policy of protecting IP, and they were basically having a policy to go into ownership and disposition of IP and copyrights, including software. Oxford was the first UK university in 1984 to develop a policy. But if you look at some of these policies, their really essential ingredient has been towards revenue sharing, okay, with significant personal benefit to inventors supported by resource technology transfer operations. So, really the whole idea is to share the revenues that the technology brings with the inventors and have a well-resourced technology transfer office. So that's what other universities are doing. So what we've done in terms of taking some actions are we've started an IP newsletter. I'm going to do a quarterly newsletter. The first one went out in March. The next one is going to come out in June. And the first issue discussed the AIA briefly is to American Rents Act. And if you're interested in receiving it, please send me an email. I'll put you on the mailing list. Right now it's circulated only to the School of Engineering faculty. Also send suggestions for future IP seminars. And we want to, as Professor Dr. Nelson mentioned, that we want to have one seminar each academic term. So your suggestions will be very, very helpful in making sure that we address what you're looking for in these seminars. And finally, in conclusion, I want to just briefly state that IP does have a lot of value, as we saw, that it's roughly about 60% of our GDP. That's the valuation of IP that the companies in the United States have today. So can this replace some of the values that we are losing in our budget cuts and salary freezes? Can we replace this concept with that? Can IP provide this soft salary support that traditionally is attributed to getting federal grants, because a lot of the faculty, especially in some areas of science, are supported through soft salary? Can IP replace that federal grant of the revenues from the IP technology transfer? Can that be part of the salary equation somehow? Those are some of the things that I just want you to start thinking about as we go forward and sort of at least embark on this whole idea of getting the faculty involved in technology transfer. Some of the hurdles that we have is that we don't have the mindset of businesses, which of course Fortune 500 have a mindset of IP, they're protecting it. We don't have that. We're still an open university kind of a thing. We want to talk about ideas. And another hurdle that we have is I've got an idea, how much is it worth? How much is the technology worth that I come up with? So those are a couple of hurdles, because if I could put a value on it, there was some sort of a system of saying that this idea that you've come up with is worth $1 billion, then we will actually take it somewhat more seriously. We don't have a system that does that. So I just want to leave everybody with those thoughts, and I'd like to have